morning, Alex, and all you viewers who are watching Court Appointed. I appreciate you being here today. We're headed downtown for pre-exam conferences. I have two, and I'll explain what a pre-exam conference is. And then after that, I've got 3 welfare fraud sentencings in front of Judge Braxton, who you saw last time. Margie Braxton, great lady, very lenient. She's going to give the bank robber a year. Welfare fraud is when you collect welfare or monies from the government and you're doing it for illegally. Let's say you collect money for your child in preschool and your kids and you're working at the same time and you're not supposed to be, so you have to pay back. They give you 5 years to pay back. What happens in Michigan is in Michigan it starts out when you get busted, they arraign you and you post a bond for whatever it is, let's say a home invasion, then you post a bond. So the people today who are out and not locked up have posted their bonds. People who are in the holding cells haven't posted their bonds. And then you have what's called a preliminary examination. We have 4 courts, and it starts out the district court that handles misdemeanors, circuit court handles felonies, and then the Court of Appeals handles appeals, and the Michigan Supreme Court. The district courts also handle what's called preliminary examinations, and that's where a crime, the police or the victim has to show a crime was committed and probable cause, or maybe my client or the defendant committed the crime. It's a very small burden. A cop just has to say, I saw 3 guys coming out of a house or going into a house and they ran away, and these are the same guys, same descriptions, and then it's a question of fact, and it's bound over to circuit court as a felony. So it starts in district court after the arraignment, and after the preliminary examination it goes to circuit court. Today I have 2 pre-exam conferences, and that's very unique to Wayne County. A pre-exam conference is even a better deal they offer you than they do at a regular arraignment in circuit court, like you saw in the last videos in front of Judge Braxton. A pre-exam conference is where they make you an offer so you don't go back to the exam in a district court. And then if you like that offer, you waive your preliminary examination because you know the cops are going to, whether they're lying or not, a lot of them don't tell the truth. That's for sure. And so you'll waive your preliminary examination, have the matter immediately bound over, waive your arraignment, plead guilty, and then you only have to come back for sentencing. Now, if there's 3 people, they'll call it a 3-bagger or a 2-bagger. That means more than one defendant. They all have to agree to waive their preliminary examination. If one agrees to waive the preliminary exam and plead, but the other 2 don't, for example, then all 3 go back for a preliminary examination, but the person who is willing to waive and plead that day still gets that offer. The other people, that offer by the prosecutor will be off the table. So today I've got 2 pre-exams, like I said. They're going to be in front of Judge Wade McCree or Judge Robbins, and both courts are next door to each other, and they have holding cells in the back for each, and the people are brought over from the jail through a tunnel. They go into the holding cells and they wait for their lawyers to come up. Now, there were some comments last time. First of all, let me explain that what we're showing is public proceedings, and the judges have given us permission to bring the camera in. Somebody mentioned, should I really be watching this? I can't recall your name, but I did subscribe to your channel and watch some of your videos. They were cool. Yeah, you should. You can be watching this. It's public record. What I say to a client, or what a client says to me, may be considered attorney-client privilege. And as long as they waive that, we can hear what they have to say on the record in court. And today we're going to try to hear what they say in the jail if they agree. If they don't agree, then we'll edit that part out. So that's what we're going to do today. And Wade McCree is a judge. His father was a judge. He's very articulate. Now, when I say lenient, someone asked me also another comment, well, do I always say that judges are lenient? In Wayne County, all the judges who do arraignments are just arraigning judges. That's where you get the best offer the first time, and they are lenient. Some are more lenient than others, like Margie Braxton may be more lenient than Judge Jimmy Shalinsky, and we haven't been to see him yet. And some people are easier to get through, like Judge Braxton may not be as, makes it a lot easier on attorneys, whereas Judge Groner, who we're going to get to see in a few weeks, hopefully, is tough on attorneys who aren't prepared and who haven't prepared their clients to say the right thing. Like, you have to make a factual basis. You have to say you knew you had a trunk, you knew you had a gun in the trunk, or you have to say you went into the bank and you robbed the bank for them to accept your plea. And a lot of people don't want to fess up. So they'll say, yeah, I didn't have drugs on me, even though they're supposed to plead to a drug case. It was, I wasn't going to sell the drugs, I was just going to give them away, which is, sharing drugs is the same as delivery. So that's what you're going to hear today. I don't know what kind of cases. One case I have is a breaking and entering into a school, and it's habitual second, meaning it's a 10-year offense, but because it's habitual second, they add half of that, so it's a 15-year felony. If it was habitual third, it would be a 20-year, and a habitual fourth is a life max. The other case is a controlled substance case, where they'll probably either possession or possession with intent to deliver crack or heroin, usually maybe weed. And they'll offer me probably probation and 10 days on the workforce. They do this in Wayne County because their docket is so full and they're so busy. They're, like I said, the third or second busiest court in the country. Whereas in Oakland County, which is a very conservative county in Michigan, they don't make these kinds of offers. People don't get a year for bank robbery. They don't get probation for delivery, or delivery second or third offense. And they do here because these arraigning judges do not like to send people to jail. There's no room in the jails. They want to give people a chance at rehab and a chance to overcome their drug problem, or a chance to show the court that they can be a good citizen. Even if they have a prior record, the judge might give them another chance. So there's also two other things I want to talk about real quickly. One is 7411. 7411 is a statute in Michigan, section 333.7411, that says basically you can get your first offense for any drug, as long as it's not delivery case, taken under advisement. So after your probationary period, it goes away and you have no felony conviction. That's for any age. As long as you can have prior record of murder, but if it's your first drug case, you're entitled to 7411. The other way to get out of a case is the Holmes Youthful Trainee Act, and I explained that earlier. That's for people between the ages of 17 and 20 who have no prior record, and that can also be taken under advisement, meaning they won't have a permanent felony conviction as long as they complete probation. So we're headed down again passing Wayne State University up ahead, and the Motor City Casino, and we'll get off again at Bagley.